So, Trevor, part of the early considerations around the UPC is for companies to decide whether to opt out their EP patents or not. And there's a lot of discussion around that at the moment in terms of the mechanics of doing it. What I wanted to focus on is the decision making in evaluating which patents should remain in and what are we likely to see being litigated in the early years of the UPC. What are you seeing, or what are your thoughts on that?
Okay. Well, I think we start with the fact that the UPC is an unknown court we have rules of procedure and we know who the judges are. And a lot of those judges are well-known, very highly respected judges in their respective jurisdictions. The rules of procedure permit of an awful lot of flexibility, an awful lot of different ways in which things could go. And we don't yet know how that's going to play out. So I think, despite the quality of the judges, there will clearly be some, certainly reluctance on the part of most patentees to entrust their most valuable assets to the UPC until they have got a sense of how it's starting to work. Now, applying that thinking, how do you then distinguish between different types of patent assets? Well, let's do it by different types of patent asset first, and then talk separately about different types of industry. In terms of different types of patent asset, you will have those people who have granted European patents. They have no divisionals in prosecution. They have no scope for getting any further patents. So those patents are there. In some cases, they may be the only patent in a family of patents. In some cases, there may be several patents in the family. And that's when I think we start getting into distinctions between different industries. When you're looking at pharma, for example, and life sciences, you tend to have only one or relatively few patents in a family. When you're looking at tech, you quite often have several patents in a family. But if you've only got one patent in the family and it's protecting an important asset, you are not, it's most unlikely that you are going to want to expose it to the UPC with the risk of that, all the designations of that patent being invalidated, all the eggs in one basket concern, which one has with the UPC, at least in its initial stages. So I think those sort of patentees are going to be looking to opt out. Patentees with divisionals or prospect of divisionals, they might be open to them to go for unitary patents anyway. And depending on the cost considerations, they might well want to do that. But I think those with a sort of, in relation to old established patents where you have relatively few patents in the family, then those people are going to be very reluctant to expose their patents to the UPC. So I think, cutting to the chase on that, probably life sciences companies, I think, are going to be a lot more conservative in their approach. I think we're going to see more opting out on the part of life sciences companies, less on the part of tech companies. Indeed, the very pressure for introducing an opt-out did come from life sciences companies in the first place.
So I think from that, you're saying that valuable assets are unlikely to be entrusted to a new court system. So could it be then that in the early years, the UPC is really seen as a second-rate court to the national courts because the really valuable IP remains litigated at a national level?
Well, it may be that the UPC does not get so many life sciences cases in the early stages. And that's particularly when you're talking about generic entry type cases, because those will be late in the life of a patent and there won't be any scope for divisionals So I don't think it'll see so many life sciences cases, but I think it is an interesting forum for tech companies. And I think we could see a lot of tech companies trying to take advantage of it. That said, they've been doing pretty well in the English courts and in the German courts. And I think also, inevitably with a new court, I think there is probably a natural human tendency to probably want to show what it can do. And perhaps it will appear to be a little claimant friendly. But there again, you look at many other jurisdictions and those seem quite claimant friendly when you come down to it at the end of the day. I don't think it will be relegated to second place at all. I think it's going to be extremely important. But I think where we're really going to see action is on the tech side.
Because you've practiced in both the US and the UK, and you're talking about sort of claimant-friendly jurisdictions, do you think that the UPC could become Europe's Western District of Texas?
Well, I should emphasize I never actually qualified as a US lawyer, but I did practice in the US, and I undertook to the New York bar that I would never purport to practice as a US lawyer. But yes.
Okay, I can reframe that question later.
the Western District of Texas, or the Eastern District of Texas, I think it is. It's traditionally the jurisdiction which attracted litigation. But actually, when you look at the figures overall, when you look at the statistics, it's not that out of whack with other jurisdictions. I think what attracted people to it was its procedures, was that it wasn't sort of booting patent cases out because it wanted to hear other sorts of cases. It wanted to actually hear patent cases. And so I think those courts in the States which have attracted patent litigation have done so because of the nature of their procedures and because they've shown that they are not exactly patent friendly, but that they are interested in hearing patent actions. And remember, in the federal district, you get all other sorts of proceedings out there. And there are judges in some jurisdictions who just do not want to hear patent actions, will just send it down to a master or whatever. So to return to your question, will the UPC compete with national courts in terms of who is the most claimant friendly, who is most plaintiff friendly? I don't know. I mean, there's a different dynamic at play as well between, for example, the UPC and the US federal courts, which is one thing we don't talk about much in relation to the UPC, but is the revocation jurisdiction. And you've got there the chance of knocking a patent out when a patent hasn't been opted out of the system, knocking a patent out for all the UPC jurisdictions, whereas an EPO opposition will knock it out for every designated state. You can knock it out for all the EPC jurisdictions in a single proceeding in the UPC. And it's very hard to bring declaratory proceedings in US courts as long as the patentee has not been too free and easy with its threats of litigation. So I think we might see quite a lot of revocation proceedings in the UPC, especially if it shows itself to have a balanced attitude towards patents, which I think it probably will, knowing the judges. And think about litigation in the UK. Most patent litigation in the UK is initiated by, the tech may have changed it a bit, but certainly in life sciences, a vast amount of patent litigation in the UK is litigation that's initiated by potential defendants, by people trying to knock the patent out or to establish that they don't infringe. So I think we may see that sort of jurisdiction developing more, and that would militate against it being a patentee-friendly jurisdiction. But obviously, it's a friendly jurisdiction towards patent litigation. It doesn't have anything else to do.
You mentioned the rules of procedure are in place and the judges are known, but that there's quite a lot of flexibility around those rules. I think one of the things that I think about when I look at a case is what's the likely outcome, and where you're dealing with a new court, an unknown court, known judges, not used yet rules. How do you think parties are going to approach considering the likely outcome of a case?
Yes. Well, I think that's the big question, really, because the rules of procedure were a mix of common law and civil law procedures. The Brits were involved, even though the Brits are no longer involved in the project, apart from Kevin Mooney personally. You've got a mix of common law and civil law thinking there. You've got different types of civil law thinking. You've got the possibility of a SAISI type procedure, for example, which is well known to the French and the Belgians and the Italians. The Dutch have started to use it, I think, but is something which is completely alien to the Germans, for example. So you've got these different judges with their different national perspectives and their national heritages. They've been attending judges' conferences. They've been talking to other judges from Europe for many years now. So they're familiar with all of these procedures, all of these different procedures. Which ones of them they're going to pick up and run with, it's very hard to say. I mean, I think the one thing which concerned people a lot about the original agreement and the rules, which is the risk of bifurcation between infringement and validity, is probably something which won't happen. I know that this is a big issue in German infringement procedures, but that is because the German courts are forced constitutionally to the infringement courts, which are state-based courts, just do not have jurisdiction over patents, which are federal rights. And so I don't think, speaking to those over the years to various German judges, they don't particularly like the split system. I think they would be very happy to be freed from the split system and to deal with both infringement and validity in the same procedure. So that is one aspect of procedure where I will stick my neck out and say, I don't think we're going to see much, if any, bifurcation. It's certainly pretty alien to most other European jurisdictions. But as to other things, will German judges, despite having no background in SAISIs or things like that, or orders for inspection, or under orders for disclosure of documents even. I've been told in many German procedures, I've been told by German lawyers, oh yes, you can get orders for discovery of documents. No, you never get the orders for discovery of documents in German procedures. But the UPC allows of it. And so whether they will actually sort of seize it and run with it, I just don't know. And I don't think we'll know until we've had the first few cases. But I think then it should settle down pretty quickly. We've got two strong Court of Appeal decisions in place who are meant to impose some sort of uniformity across the different divisions. So I think we should see fairly soon how things are playing out in that respect.
Thanks, Trevor. I think from my side, it's a little bit terrifying that you're going to have judges from lots of different jurisdictions having a pick and mix approach to the different things and tools and toys that they can play with from other jurisdictions in the early days, and testing different aspects of the procedural rules. It's going to make it quite difficult to kind of predict which way things are going to go, and not being able to use track record, particularly for the German judges, if they depart from their national kind of procedures, is going to be an interesting prospect for those managing litigation risk. So bifurcation between infringement and validity, you think is unlikely. What about damages? So in the UK, we obviously have a bifurcated system between liability and quantum. What do you think the UPC will look like, given that there's a one-day hearing?
Well, I think the damages phase is a sort of separate phase, actually, in my reading of the procedure.
I thought it was optional.
Well.
But I might be wrong.
No, I think you probably are right, because absolutely everything in the rules is optional. The court has an enormous discretion to waive various provisions of the rules, to extend time limits, do this, that, and the other. No, I mean, the only reason why, for example, in the United States, you do not bifurcate the liability phase and the damages phase is because you need to have the same jury adjudicating on both of them, and you can't get the same jury back sort of several months or a couple of years down the road. And there's this constitutional requirement in the States for any infringement action in which any sort of sum, I think it's over 50 cents or something, I don't know, but has to be heard, has to have the possibility of being heard in front of a jury. So, I mean, any sensible system, unless it's forced by its constitution to do it that way, is going to bifurcate liability and damages. So they're completely different issues, completely different evidence is involved, and all the money you spend on damages inquiries is a complete waste of time if there's no liability. Well, speaking as an English lawyer, the cost of damages inquiries is actually can often be higher than that of the liability side of the action, because you're paying for all this accountancy evidence, and that does not come cheap.
So the UK is now not part of the UPC and could be an alternative jurisdiction in a system which is known with known judges. How do you think strategy is going to move forward in terms of use of the UK versus the UPC, or running in parallel?
Well, I mean, at present, a lot of UK litigation in the life sciences side is litigation that is brought to revoke patents. And one of the reasons why the UK is a favoured forum for that is that you don't need to establish any locus, as you do in certain European national jurisdictions, and you get an answer, a fully reasoned answer, pretty quickly. And you then have a hope, as somebody seeking to knock out the patent, that if you can trail that around various European jurisdictions, it will influence the judges in those jurisdictions. So I think in the life sciences side, that will probably continue, especially because, as I say, it's likely that a lot of life sciences patents, at least late in their life, will be opted out anyway. So the UPC just won't be an option for them. I think, until we've seen the nature of some of the judgments in the UPC, the very fully reasoned judgments of the English courts will continue to carry weight. And I mean, it's interesting how over the years you have seen that the German and Dutch courts in particular have started to produce much more fully reasoned judgments to compete, if you like, with the English court. I was once told by a French judge that it's not the done thing to show too much reasoning in a French judgment, because it's It's something they're sort of taught at judge school. It may be entirely apocryphal, but I must admit I've never found the reasoning in French judgments that helpful from that point of view. But perhaps freed from that, French judges will now be able to provide full reasoning. Now, in tech, I don't think there has been so much of that trend, and indeed in tech, it is normally the case that it's the patentees who bring proceedings and not the people who are at risk of being sued. And certainly with the FRAND jurisdiction in the UK and the idea of the FRAND injunction, there is every incentive, if you like, for somebody seeking to enforce a standards essential patent to bring the proceedings in the UK. Again, those proceedings will get to trial pretty quickly. Perhaps the time to trial is not so fast. Or the time to trial in the UK, the difference between the time to trial in the UK and the time to trial in the UPC will not be as great as the difference between the time to trial in the UK and most European national jurisdictions. I mean, notable difference is the Dutch, who are pretty fast, and the German infringement jurisdiction, which is fast, but of course the German revocation nullity proceedings take a lot longer. So perhaps the UK's benefit in terms of speed to trial, the speed to getting a decision, will be less important than it used to be. But still, the UK and Spain will be two major national markets which are outside the UPC. I don't know if you've had experience of litigating in Spain, but the procedure there is very front-loaded. You have to put all your evidence in at the outset. And there's very little scope to add anything along the way. So it's a bit scary from that point of view. But I think the UK, as I say, is still a major market. And from that point of view alone, you'll probably want to include that in your strategy. It'll be some time to come before we start seeing UPC judgments waved in front of the English judges, told that they should be following the same line. But of course, we are all applying pretty much the same substantive law, and you will be seeing the first judgment on any sort of European patent in any forum will be shown to the other judges. But I think, as we've seen already, that happens. The judges feel the need to now, thankfully, feel the need to explain, if they are differing from their colleagues in other jurisdictions, why they are so doing. But certainly they don't blindly follow each other's decisions. That has to be said.
So you mentioned it's going to be a while before UPC judgments are waved in front of the UK judges. At the AIPPI event earlier in the week, they were talking about the long arm jurisdiction of the UPC. How does that work? And will it actually lead to the UK needing to enforce UPC judgments over the UK designations of not opted out patent?
Yes. The long arm jurisdiction of the UPC that people refer to reflects the fact that it's effectively a party to the Brussels I regulation. And therefore, although it doesn't have jurisdiction over validity questions in relation to patents outside the UPC member states, it does potentially have infringement jurisdiction over patents elsewhere in the EU via the Brussels I regulation, and arguably elsewhere in the EEA and Switzerland by virtue of the Lugano Convention, although the Lugano Convention hasn't been amended in the same way as the Brussels I regulation. And that also, the other aspect of the long-arm jurisdiction is you can effectively enforce a judgment of the UPC as of right in the rest of the EU and arguably the EEA and Switzerland by virtue of the Brussels I regulation in the first case and the Lugano Convention in the second case. Now, from the point of view of the UK, we did apply when we left the EU to join the Lugano Convention, but the Commission put the kibosh on that. They said it wasn't a good idea. And so the UK is a third country in every respect. And I don't see any scope for the UPC to have long-arm jurisdiction over the UK, or at least not in any enforceable sense. You know, you have in the early days of when the Dutch courts were developing the sort of pan-European injunction, it's sometimes forgotten that they had also granted injunctions over infringement in South America or things like that. They didn't feel trammeled in any way, despite the obvious difficulty of enforcing these things. So I wouldn't exclude the possibility of a court purporting to make an order which extended to the UK, but I don't see any way of enforcing it apart from having to go through all the palaver in the UK and just showing, effectively running an infringement case again to show that the order was rightly made.
So one of the concerns that's been voiced is that the wider jurisdiction of the UPC is going to encourage more NPE litigation to come to Europe. Do you think that the new court could be a new sort of US type jurisdiction, which is going to see a significant increase in NPE litigation? Or do you think that the cost shifting regime may discourage some of the, I'm going to say, less attractive cases that we see in the US?
Well, I think NPE litigation tends to be in the tech area, and it also tends to involve patents which have not been validated in that many countries. I think if you look at patents in the telecoms area, I mean, it has perhaps changed a little in recent years, but it used to be the case that people would only validate in the biggest markets. And so, if you've not validated in a country, then it's irrelevant that it's part of the UPC. You don't get damages in relation to that country. But I think that also, that decision about where you validate it also reflects a judgment about the, economics, that in many of these smaller jurisdictions, it just isn't really worth the candle if you look at those jurisdictions individually in many areas of technology. The one area where you do see widespread validation in just about every single jurisdiction is pharma. And they will fight everything in every jurisdiction. It's well worth it if you're fighting against a generic entrant. It makes it worthwhile. But in other areas, it's not. And so there is only a certain limited market out there which you can assert your patents in respect of because you've only validated them in certain countries. Now you might say, well, an NPE wouldn't want to be suing in every jurisdiction, so it would make sense for it to sue in the UPC. I think if you've got to balance that, for example, against the attractions of suing on SEPs in the UK. But there are many other patents, implementation patents, which NPEs will hold. And the UPC may have attractions for them from that point of view, and they will have the potential of getting damages in relation to every jurisdiction in which the patent has been validated. And that may have been something they might not have chosen to do in terms of litigation. But in terms of any settlement they would do with somebody at the end of the day, and what the MPEs really want to do is make a settlement, they for sure would be factoring in, even if they'd only proceeded in one jurisdiction, the potential damages in other jurisdictions, unless the person on the receiving end had sort of started revocation proceedings or non-infringement proceedings or whatever in those jurisdictions. So I suspect at the end of the day, at least initially, it's not going to be so much more attractive for MPEs from that point of view. Where I think you might see things changing is if you're looking at all of Europe and the potential of being able to sue in relation to a market which is as big, if not bigger, than the United States, the attractions of the unitary patent start to factor in quite a lot. And I suspect that those MPEs with divisionals still open to being prosecuted will certainly be exploring that sort of avenue and actually monetizing those jurisdictions which have never previously before been monetized because patents weren't validated in relation to those jurisdictions.
So I think that the UPC is going to be a slightly more expensive forum than some continental jurisdictions, maybe approaching a UK type cost for bringing a case. How will claimants fund their litigation? And obviously, coming from a funder, that is an option. But I think there are other options for the UPC. In the UK, we obviously have contingency agreements. They're not permitted in Germany. So I don't know how that dynamic is going to come into play. Also, I understand there's some sort of legal aid provision which is available in the UPC. What are your thoughts around the options that are available and who they're available to?
Well, I must admit, I wasn't even aware of the legal aid provision until you brought it to my attention. As an English litigator, it's so long since I had anything to do, English IP litigator, it's so long since I had anything to do with legal aid, which used to be available in the UK for IP cases, but is no more. That I was fascinated to see it in the UPC agreement, and a bit of flesh put on the bones in the UPC rules. I think its inclusion in the agreement probably reflects some underlying consideration under the European Convention of Human Rights as to access to justice. And reflecting that, my reading of the rules, and I haven't been back to the agreement itself from this point of view, is that legal aid is available, but only to natural persons, not to companies. The entire discussion in the rules is very much keyed to sort of family circumstances and what the other members of your family, their income, their assets, this, that, and the other. And so, when you look at the rules, it says in order to ensure effective access to justice, the court may grant legal aid, and it's pretty vague about the various parameters which are applied. It can't be more than the permitted costs recovery, but depending on the amount in issue, that could be quite a lot. But it requires you to be able to show as an applicant that owing to your economic situation, you're wholly or partly unable to meet the costs. And we just don't know how that is going to be applied in practice. We have no particular criteria which are applied. The number of factors you take into account, the registrar can take into account, and there's an appeal procedure. So We just don't know how that's going to work. But I think one has also to recall that the UPC is meant to be self-funding after its initial setup period. I don't know, and we don't really have any transparency as to how they fixed the fee structure, given the need to pay for all the judges, need to keep pay for all the IT, everything else. If, for example, all you get is revocation proceedings and no infringement proceedings, they just won't be able to pay for it eventually. Obviously, there's pump priming money goes in the start. But so I have to imagine that they're not going to be very free and easy with the grant of legal aid. I think in terms of the costs, the fees are potentially very high. They can go up to over 300,000 for very big claims, and the costs recovery, permitted cost recovery for very big claims can be up to 2 million. But I think the other point I might make about the fees is that there is a reduction to 60% of the fees for SMEs. And so that should be borne in mind as well. I don't quite know how litigation funding factors into that calculation. But there again, as with everything else, the court has an enormous discretion to do all sorts of things and to waive the fees and to order repayment of fees it thinks should have been paid and things like that.
So we've talked about the judges, we've talked about the types of organisation and the types of patents which we might see in the early stages. What about the advocates? So the UK solicitors do not have standing, but European qualified patent attorneys do. Obviously, patent attorneys have experience of opposition at the EPO, but litigation is a little bit different. Do you think we're going to see more patent attorney advocates in the UPC, or do you think it will be structured in the sort of German way where you have a litigator and a technical person supporting them?
I think there's probably a lot to be said for having advocates with both sets of skills. And certainly, I've always thought that the people who would probably do very well in the UPC sort of system would be the Dutch advocates, because they're very good all-rounders. And I think the number of German, because of the split system in Germany, the number of German litigators who also have a technical background is very small. Now, a number of the litigators have a very good grasp of the technology, so would be well able to argue these points. But one should also remember that in German proceedings, it's quite often when they're in the infringement proceedings, when, for example, you're arguing for a stay or something like that, it's the patent attorney who will be making the argument. So I think in terms of all-rounders, we should be looking at probably the Dutch more than, and it could also level the playing field. Traditionally, Germany has had so much of the lion's share of European patent litigation. This provides enormous opportunities for advocates from across Europe. And as to patent attorneys, and certainly UK patent attorneys, I think we don't recognise how successful the UK patent profession has actually been since the establishment of the EPC. What a large share of the patent attorney profession in Europe the UK patent attorneys have, and also the respect and the market share they have in relation to highly contentious opposition proceedings. And I've been in opposition proceedings in Munich where you have a corridor of opposition proceedings, and every single person, and there was a Brit arguing every single case. Most of them were virtually all patent attorneys, obviously. I was a sort of lone solicitor. But it shows you quite what the skills that UK patent attorneys have. And so I think the only problem they have is probably just resources. Are there enough of them? They've got so much other work to be doing. Are they going to want to take this on as well? I think some firms have clearly shown they do want to. Some firms have, for a number of years, taken on solicitors and will actually litigate perfectly happily in the English courts using those solicitors. And I think a number of them would love the opportunity and very much relish the opportunity and be excellent advocates in this sort of proceeding. And you remember, this sort of proceeding places no premium on cross-examination, for example, because whilst you can have live evidence from experts, and how the courts deal with the expert evidence is going to be very interesting, rules do not envisage direct cross-examination. The rules envisage that it's going to be the court that is going to cross-examine the experts, for example. So I don't see any reason why a UK-based European patent attorney wouldn't be able to argue these things. And the only other profession in Europe, which is, and obviously the German profession is much bigger, but there again, I think their relationship with the lawyers means that they haven't necessarily had the experience of dealing with the infringement aspects so much. So I think that could be very interesting to see how that plays out.
Are you excited about the UPC, Trevor?
Well, I mean, the UPC is an extraordinarily exciting development in Europe. It's the biggest development in patent litigation in Europe since the EPC back in 1973, or back in the 1970s at least. And it's certainly going to shake up patent litigation in Europe in a major way. And it's going to be fascinating to see how it all works out. It's something very exciting to watch.